Imagine waking up with this terrible flu on the second week of your brand new job in Germany.
Oh, yeah. That is the absolute worst timing.
Right. I mean, you do the responsible thing, you stay home, you rest, you try not to infect your new colleagues.
Exactly.
But then, at the end of the month, you check your bank account and your paycheck is exactly zero.
Yep. Welcome to the invisible tripwires of German labor law.
It's terrifying. And if you are an expat living and working in Germany, you're walking that tightrope right now.
You really are. I mean, people tend to think of legal protections as this simple binary, like you're either protected or you aren't.
Right. But it's not that simple, is it?
Not at all. It's this complex web of conditions, exceptions, and crucially burdens of proof.
So today, our mission for this deep dive is to demystify one of the absolute pillars of German labor rights. It's called the Entgeltfortzahlungsgesetz.
Or the EFZG for short.
Thank goodness for acronyms. Basically, in plain English, that's the law on the continued payment of wages during illness.
Right. It's essentially the rule book for what happens to your livelihood when your body just, decides it needs a break.
Exactly. And we want to equip you, the listener, with the exact knowledge of your rights, your obligations, and the evidence you need if your employer pushes back.
Because they absolutely will push back.
Oh, totally. Now, I want to note right at the top that all the legal commentary and source material for this deep dive has been provided by Attorney Kiril Stawrew, based in Berlin.
Yeah, and his firm specializes in this exact kind of labor dispute, which is super helpful.
It really is. What's great about the briefing documents from law firm Kiril Stawrew is they don't just list dry regulations.
Right. They dive into the actual legal battles. Like what happens when an employer just flat out doesn't believe you're sick?
It's a high-stakes game of proof.
Yeah.
So let's start with the safety net itself, the core concept.
Right. So the fundamental right under the EFZG is actually incredibly generous by international standards.
Okay, lay it on us.
If you're an employee in Germany and you can't work because of illness, you are entitled to 100% of your regular wages for up to 6 weeks.
Wow. 100% for 6 weeks.
Yeah, 42 calendar days paid directly by your employer, just as if you'd been sitting at your desk.
That is a massive relief.
Ugh.
But okay, I have to go back to my opening scenario.
The second week flu.
Yeah, if I just moved to Berlin, started a new marketing job on Monday, and caught that flu on Wednesday, do I really not get paid?
Well, you did not get paid by your employer.
Wait, seriously?
Seriously. The law has what's known as a 4-week waiting period. So during the first 4 weeks of a new contract, the employer has zero legal obligation to pay your wages if you fall ill.
I mean, I need to understand the logic there, because on the surface, that feels incredibly punitive to someone who just had bad luck.
It does seem harsh, right? But it helps to view the EFCG as a risk-sharing contract.
Okay, how so?
Well, 6 weeks of full pay for zero labor is a huge financial burden for an employer. The waiting period protects them from absorbing that massive risk before you've actually contributed any work.
Ah, I see.
Yeah, it prevents a situation where someone with a chronic condition signs a contract and immediately goes on 6 weeks of paid leave without ever working a single day.
Okay, I see the employer side of it now. It's like a probationary period for financial risk.
Exactly.
But back to the employee, are they just left to starve in week 2?
No. The broader social safety net catches you. Instead of your employer paying, your statutory health insurance steps in.
Oh, good. What do they pay?
They pay a benefit called Krankengeld, or sick pay. It's roughly 70% of your regular gross pay.
Okay, capped at what?
Capped at 90% of your net pay. So
Yeah.
you do take a financial hit during those first 4 weeks.
Right, but it's better than nothing.
Definitely. And once you cross that 4-week anniversary of your start date, the employer is officially on the hook for the full 100% going forward.
Got it. Now, knowing that safety net kicks in is great, but I'm assuming you can't just vanish into bed and wait for the direct deposit.
Oh, absolutely not. That is a huge mistake. German labor law demands a dual duty from the employee before any money changes hands.
Okay, what are the 2 duties?
The first is the Anzeigepflicht, the duty to report, and the second is the Nachweispflicht, the duty to prove.
Let's break down the duty to report first. The material from Attorney Stawrew is very clear. You have to notify your employer immediately on day 1 of your illness.
Yes, and you have to give them an estimated duration.
And immediately means what, exactly?
In a legal context, it means without any culpable delay. If your shift starts at 9:00 a.m., you can't wait until 2:00 p.m. to send an email saying you won't be coming in.
Right, because the business needs to know you're not going to be there.
Exactly. They rely on predictability. But notice you do not have to disclose what is wrong with you.
Oh, really?
Yeah, your medical diagnosis is strictly private. You just must inform them that you are incapacitated and roughly how long you expect to be out.
For an expat, this is doubly stressful. You're navigating a new work culture, worrying about how a sick day looks to a new boss, and now you have the duty to prove it.
Ah, yes. The famous AU, the Arbeitsunfähigkeitsbescheinigung.
Right, the medical certificate. Now, the standard rule of thumb I've always heard is that you need a doctor's note if you're sick for more than 3 consecutive calendar days.
Right.
So you handed it on the 4th day, is that correct?
That is the standard statutory default, yes. If you are sick Monday, Tuesday, and Wednesday, you legally need that note covering your absence by Thursday.
Okay, seems reasonable.
However, and this is a significant caveat that catches a lot of people off guard.
Uh-oh, the day one trap.
The day one trap. Employers have the absolute legal right to demand a doctor's note from the very first day of illness.
Wait, without giving a reason?
Without providing any justification whatsoever, none is required.
They can just decide they want a note immediately.
Yeah.
Even with no prior history of you faking an illness.
Yep. They can embed this requirement universally in your employment contract, or a manager can just demand it on a case-by-case basis.
Wow, so if I just assume I have 3 free days to sweat out a fever on the couch, and they've invoked that right.
They can legally withhold your pay for those days.
That is a critical piece of advice. Definitely check your specific contract.
Absolutely.
Now, speaking of getting that doctor's note, we have to talk about the recent digital revolution in German healthcare, the EAU.
Oh, the electronic sick note system. It fundamentally changed the administrative landscape.
Yeah, I kind of think of it as a digital baton pass. I go to the clinic, the doctor magically beams the sick note to my health insurance, and then my employer pulls it from the cloud.
It does sound incredibly efficient.
Right. Doesn't that mean I can just stay in bed, drink my chamomile tea, and let the computers handle the bureaucracy?
I am so glad you used that analogy because it highlights exactly where the system breaks down.
Oh no, where does it break?
Well, yes, it's a digital baton pass, but your employer doesn't know they are supposed to be running the race unless you tell them.
Right.
The EAU system automates the duty to prove. It does absolutely nothing to replace your duty to report.
So if I don't send that initial "I'm sick" email, the HR system doesn't just get a pop-up notification from my doctor.
Not at all. The employer has to actively query the health insurance database to retrieve your electronic note.
Okay, so if I don't tell them, they don't look.
Exactly. You could be sitting at home thinking the computers handled everything while your employer fires you for being absent without leave.
That is terrifying, especially when you factor in language barriers for expats.
Right. Trying to explain your symptoms in broken German is hard enough without the anxiety of the digital portal failing.
Plus, this digitization introduces a fascinating shift in the workplace, right? Because the digital note is deliberately stripped of certain information.
Yes, to protect your medical privacy. Historically, you handed in a physical piece of paper that might have had the stamp of a specific specialist.
Right. If I handed in a pink slip stamped by an orthopedic surgeon, my boss could reasonably assume I threw my back out.
Exactly. But today, the employer just receives a blank digital confirmation.
Oh, wow.
They don't see the doctor's name, their specialty, or their location. They know less about your condition than ever before.
Which is a massive win for patient privacy, sure. But I can see how that information vacuum could fuel suspicion if a manager is already prone to doubting their team.
Precisely. Which leads us to the next critical layer of the law. Assuming you reported on time and your EAU is in the system, your employer still isn't automatically forced to pay you.
Wait, what else is there?
The EFZG requires that the illness must be unverschuldet, meaning not your fault.
Okay, I want to clarify the definition of fault here because that sounds super subjective.
It can sound that way, yeah.
Like, if I catch food poisoning because I ate a discount gas station hot dog at 2:08 a.m., is my boss going to claim it's my fault?
No. German labor courts do not police your everyday bad decisions.
Thank goodness.
Fault, in this specific legal context, requires a very high bar. It is defined as a gross violation of reasonable behavior in your own self-interest.
So, like, acting super recklessly.
Yes, you have to act so recklessly that it would be fundamentally unfair to shift the financial burden onto your employer.
What does a gross violation look like in practice? Give me some examples.
The classic examples found in case law include injuries from participating in a provoked bar brawl, drunk driving, or blatantly ignoring established safety protocols at work.
Okay, what about sports?
Ah, sports are interesting.
Yeah, because what if an expat joins an amateur rugby league? Or does amateur boxing? If I show up on Monday with a concussion from a boxing ring, can my employer refuse to pay?
It's a logical question, but the legal commentary specifically notes that participating in a recognized, regulated sport, even boxing, is not considered a self-inflicted fault.
Wait, why is a boxing match protected, but a bar brawl isn't? They both involve getting hit in the face.
It comes down to the manner and context of the action. Society recognizes that sports have intrinsic physical and social value.
I guess that makes sense.
Yeah, as long as you're adhering to the rules of that sport and not acting with gross recklessness beyond the normal scope of the game, you're protected. A drunken street fight operates outside of any rules.
Okay, the law looks at the structure of the risk.
Yeah.
But let's say it isn't a bar brawl. What if your employer just looks at the timing of your sick leave, sees the blank EAU, and decides you're faking it?
Ah, yes.
Like maybe it's late December, you ran out of vacation days, and they think you just wanted an early holiday.
This is where we enter the battlefield of evidence.
The briefing documents from law firm Kiril Stawrew gave us a really detailed look at a recent case from the Lower Saxony State Labor Court. Let's dive into this.
It's a perfect example of how these disputes play out in the real world. To understand it, we first have to understand the power of the doctor's note.
The Beweiswert, right?
Yes, the evidential value. In German law, when a doctor issues an AU, the court presumes it is a stated fact. It's the foundation of your claim.
So the employer can't just say, I have a bad feeling about this.
Exactly. They cannot just refuse to pay you based on office gossip. They need concrete, factual evidence to challenge that foundation.
But in this Lower Saxony case, the employer tried to completely undermine that foundation. So here's the setup for you listening. An employee is terminated by her employer in mid-December.
Okay.
She immediately calls in sick. But she doesn't go to a clinic. She gets her doctor's note via a telephone consultation.
A detail that becomes very important later.
Right. Now add this to the mix. Her partner happens to work at the exact same company.
Oh, wow.
Yep. He quits his job at the exact same time she is fired, and magically, he also gets sick immediately.
You can certainly understand why the employer's suspicion was triggered there.
Oh, I'd be suspicious too. If a couple suddenly both go on sick leave the moment their employment ends, skipping their notice periods, it looks incredibly coordinated.
It really does.
The employer actually drove to her house on a Sunday, demanded the company car and laptop back, and refused to pay her wages for December, saying it was a staged illness.
It is a perfect storm of circumstantial evidence. So the employer goes to the labor court and actively challenges the evidential value of her sick notes.
How did the court rule? Did the employer win?
It resulted in a very nuanced decision. The court scrutinized exactly how the medical certificates were acquired.
Because she got them over the phone.
Yes. She submitted an initial sick note, followed by several follow-up notes to extend her leave. The court noted those follow-up notes were issued purely based on telephone calls for an extended period.
And that's a problem.
It was here. Because the special pandemic-era rules allowing long-term telemedicine sick notes had expired, the court determined the doctor violated standard medical guidelines by not examining her in person.
So because the administrative process of getting the note was flawed, the note was thrown out.
Not entirely thrown out, but its foundation was undermined. Its evidential value was considered shattered.
Oh, well. Shattered.
And this is the vital legal mechanism every employee needs to understand. When an employer successfully shatters the Beweiswert, the burden of proof shifts entirely back to the employee.
You can't just point to the piece of paper anymore and say, talk to my doctor.
Exactly. The shield is gone. The employee now had to prove to the judge in granular detail that she was genuinely incapacitated.
How do you even do that?
Well, she claims she was suffering from severe gastrointestinal cramps. To prove this in court, she had to formally release her treating physicians from their strict medical confidentiality obligations.
So the doctors could testify about her specific symptoms.
Yes, or provide detailed medical records.
Having to describe the severity of your stomach cramps to a labor court judge? That is incredibly invasive.
It highlights how high the stakes become once the sick note is invalidated.
So what happened? Did she get her money?
The court reached a middle ground. They found that the employer's theory of a coordinated action wasn't sufficiently proven just because her partner quit.
Okay, so she won that part.
Right. Furthermore, her very first sick note was deemed valid. So they ordered the employer to pay over 1,000 euros of her wages.
But not the full amount.
No, because the follow-up notes were shattered by the telephone consultation issue. She couldn't legally prove the prolonged duration of her illness.
The takeaway here is huge. A doctor's note is powerful, but it is not invincible armor.
No, it's not.
If there is an administrative error or the context looks highly suspicious, your employer can challenge it. You need to be prepared to back up your claims with real documentation.
And it really underscores why following proper medical procedure is your best defense. An aggressive employer will look for any technicality to undermine your claim.
So true. All right, let's move to one final incredibly complex tripwire in the EFZG. The same illness loophole.
The Fortsetzungserkrankung.
Right. This deals with how the 6-week payment limit is calculated if you have multiple illnesses or a chronic condition.
Yes.
Let's use a hypothetical. I have appendicitis. I am in the hospital, out of work for exactly 6 weeks, fully paid by my employer. I am finally recovering. But literally on the evening of the last day of my 6-week leave, I bend over to tie my shoe, and I slip a disc in my back.
Oh, brutal luck.
2 completely unrelated medical emergencies. Do I get a brand new, fresh 6 weeks of paid leave for the back injury?
If the timelines are completely distinct, yes. If you were cleared for work from the appendicitis and then hurt your back, you get a fresh 6 weeks.
Okay, great.
However, German law applies a very strict overlap rule. If you suffer the slip disc while you are still formally on sick leave for the appendicitis,
Even if it's just by a day.
even if the timelines overlap by a single minute, the law treats them as one continuous period of inability to work.
Wait, really? Even though a bad back has absolutely nothing to do with my appendix?
Correct. The medical relationship doesn't matter if the timelines intersect. If they overlap, you are capped at a total of 6 weeks of employer-paid leave for that entire stretch of time.
That is brutal. It really penalizes sheer bad luck.
It does, but again, the law is designed to place a hard ceiling on the employer's financial exposure.
Hits.
No, they do not. The law tracks absences that stem from the exact same underlying medical condition.
Oh, so they group them.
Yes. If your absences are all caused by the same chronic migraine issue, those individual days are added together into one running total. You don't get a new 6 weeks for every flare-up.
I am genuinely confused by the math on this. Do I just eventually hit 42 days for migraines and then my employer never has to pay me for a migraine ever again?
No, it's not a lifetime cap. The law provides 2 specific reset buttons, the 6-month rule and the 12-month rule.
Okay, walk me through them.
You only get a fresh bucket of 6 weeks of employer-paid leave for that specific chronic illness if you meet one of 2 conditions. Condition 1, you have not been sick with that specific illness for at least 6 uninterrupted months.
Okay, let me test that. If my last migraine was in May, and I make it all the way to December without missing a day for a headache,
That is over 6 months.
so the clock resets.
Exactly. If you get a migraine in December, you start with a fresh 6 weeks of coverage.
But what if my condition is severe and I never make it 6 full months without an episode?
Then condition 2 applies the 12-month rule. A fresh 6 weeks is granted if 12 full months have passed since the very first day you called in sick with that specific episode of the illness.
Okay, let's see the timeline for that.
Say your chronic migraine flare-ups began on January 1st. Throughout the year, you take a few days off here and there. You never go 6 months without a headache. So the first reset button never triggers. You eventually use up all 42 days of employer pay. But on January 1st of the following year, exactly 12 months since the initial start, the system legally resets.
Oh, I see.
Yeah, your employer is once again liable for up to 6 weeks of pay for migraines in that new 12-month cycle.
The precision of that is just staggering. It perfectly illustrates the duality of the EFZG. It is a deeply protective social safety net, but heavily regulated mathematically.
It's a constant, delicate balancing act between an employee's fundamental right to heal and a business's need to survive the financial strain.
We have covered a tremendous amount of ground today. If you are an expat working in Germany, the takeaway is clear. The EFZG gives you an incredible shield, but you have to read the instruction manual.
Absolutely.
You must report your absence immediately on day 1. You must secure your doctor's note. And as we saw in the Lower Saxony court case, your digital sick note is not a magic wand if your employer brings concrete evidence to challenge it.
Knowledge of the procedure is your absolute best defense.
Without a doubt. And if you are listening right now and realizing that your employer is doubting your illness or withholding your wages, you do not have to fight the system alone.
Definitely not.
You can reach out directly to law firm Kiril Stawrew in Berlin. They provided the legal commentary for our deep dive today, and they specialize in protecting employee rights in these exact disputes.
They do excellent work.
You can contact their office and apply for a free initial consultation, a kostenlos Erstberatung, to ensure your rights are secured.
Having a legal expert objectively evaluate whether the evidential value of your sick note has actually been shattered is an invaluable step before taking further action.
I couldn't agree more. Before we wrap up, looking at all this through the lens of the new EAU system, there is a fascinating tension building here.
It really raises a profound question about the future intersection of labor and medicine.
Because of the digital distance.
Yes. As telemedicine and digital health records become the absolute standard, the physical distance between the doctor, the patient, and the employer is widening drastically.
We saw exactly that in the court case.
Right. If an employer can no longer see a doctor's specialty because of strict privacy laws, and if your doctor is diagnosing you over a quick video call, how will the labor courts of the future balance your right to medical privacy against an employer's right to demand rock-solid proof?
Wow, yeah. As technology pushes all the human elements further apart, these legal battles over trust are only going to become more intense.
It's definitely something to watch.
The tightrope is getting higher, and the digital age is making those tripwires a lot harder to see. Thank you so much for joining us on this deep dive.
My pleasure.
Stay curious, stay well informed, and watch your step out there.